Good morning to all of you, dear students, particularly the 5th SEM CPC students. We are discussing the topic place of suing or venue of trial. So in the last class, I told you the topic jurisdiction. You may be knowing juris means by law, diction means I speak by law, or in other words, jurisdiction means the authority to execute the law in a specified area, that is the designated area for the court. Right? Sometimes there may be differences regarding the jurisdiction. So as per the place of suing, section 15, I told you that you have to file the suit in the lowest grade jurisdiction, lowest grade court, that is normally JCJ. But as far as 16 is concerned, where the property is located, particularly immovable property, where it is located, and 17, if it is located in different courts jurisdiction, it is your option. You can file in one of the courts according to section 17. According to section 18, when the jurisdiction is doubtful, we are not certain, when you are not certain about the jurisdiction, you can take permission. The court will record and it will take up the trial of the matter. Of course, section 19 relates to personal wrongs. So there also you have to remember that the suit should be instituted where the cause of action takes place or where the defendant resides. Please remember, not where the plaintiff resides, where the defendant resides. Right? So if you are doubtful, if the above types of suits are not there, if other suits are there, you can file where the cause of action takes place or where the defendant takes place. Right. Now, as far as the objections are concerned, section 21 is very clear. Objections regarding jurisdiction. Right. So please remember, whenever you want to raise objection for the jurisdiction, you have to do it in the initial stage and at the entrance court itself. If you don't raise objection, even though you raise objection in the appellate court or revision court, it will not be allowed. That is what section 20 says. Right? You may be knowing about section 22. This is transfer of cases, transfer of the suits. Maybe due to the defendant's inconvenience or the plaintiff inconvenience, it can be transferred. Of course, even the Supreme Court of India, according to section 25, Supreme Court of India also can transfer the cases. Now, yesterday, actually, on 6/11/2020, Honorable Justice V. Ramasubramanian of Honorable Supreme Court of India, he has given judgment on touching objection to jurisdiction as well as transfer. Actually, this petition was filed for transfer, but he touched the topic of jurisdiction also. That's why it becomes an important case for you. So now let us go to the case. While disposing the transfer petition civil number 975/2020 on 6/11/2020 in the case of Indian Olympic Association versus Kerala Olympic Association and others. Right, 22 very recently. Justice Ramasubramanian held that when you feel that there is lack of jurisdiction, when you want to raise an objection, you have to do in the initial stage, but not on the later stage. And you cannot do forum shopping by filing a transfer petition. Actually, yes, if you go into the details of the case, then you will be knowing the same better. So you may be knowing Indian Olympic Association. It's an association registered in the Cooperative Society, duly registered in the Cooperative Societies Act, and its headquarters is located in Delhi. A subsidiary association by name Kerala Olympic Association. It was formed and actually it is abiding by the rules and regulations of the main association IOA. And of course, as you know, fencing association, hockey association, Olympic association, all these things normally there will be disputes between the parties and everybody tries to start his own association and there some glitches will take place. Same thing happened with the Kerala Olympic Association. On 14/1/2019, the elections to the Kerala Olympic Association were scheduled to be held. But of course, somebody has gone to the court that the procedures are not being followed, all these things. Therefore, Kerala High Court directed that the elections to be held under its supervision. That is to say, on 14/1/2019, the elections to Kerala Olympic Association were held under the supervision of Kerala High Court only, right? But it was not satisfied to some persons, so therefore they filed a representation to the Indian Olympic Association, right? This Olympic Association, there is a committee called as the Ethics Committee, the Ethics Commission actually they told, the Ethics Commission, they wanted to decide conduct an inquiry to the matter. Therefore, they sent a notice to the Kerala Olympic Association that they wanted to get all the information how the elections were conducted, and the allegations are that some malpractice taken with other things. So they wanted to conduct an inquiry, but Kerala Olympic Association stated that you don't have a locus standi, or you cannot conduct the inquiry because this matter was already taken up by the Kerala High Court. Somebody went to the Kerala High Court and they got the orders under the supervision of Kerala High Court only. The elections were held. Therefore, they have filed a writ petition number 2938/2020 before Kerala High Court challenging the notice. That means notice given by the Indian Olympic Association. That means they wanted to give a writ of mandamus to the Indian Olympic Association not to conduct any inquiry because already the Kerala High Court supervised the elections of the same. Right? Now, intelligently, the Indian Olympic Association, they filed an objection and they wanted to get the case transferred to the High Court, Delhi, because of a bylaw. Indian Olympic Association, they wanted to depend on the bylaw 331.3, that is Rule 31, Sub-Rule 3. It says, the association may sue or be sued in the name of Secretary General, Indian Olympic Association. A lawsuit can only be filed in New Delhi, which is the headquarters of Indian Olympic Association. So, at the time of bylaws, at the time of registration of this Kerala Olympic Association also, it was clearly mentioned that if any dispute is there between the Indian Olympic Association and Kerala Olympic Association, the matter has to be filed as a civil suit in the Delhi High Court only. But now they have filed here. So actually, it is lack of jurisdiction, definitely. But instead of that, they wanted a transfer. Instead of section 21, they have invoked section 22 of the CPC. Now, Justice Ramasubramanian stated that since you are focusing on transfer, there is absolutely no necessity to transfer the case from Kerala High Court to Delhi because entire thing was supervised by the Kerala High Court. Entire incident, cause of action took place in Kerala High Court area. Therefore, transfer is not allowed. Finish. At the same time, he had touched the topic of jurisdiction. He said, when you raise the topic of objection for jurisdiction, you should have objected from the initial stage. That means when the High Court, before the High Court interfering into the issue, you should have raised the objection that the Kerala Olympic Association has no jurisdiction and whatever is there, it has to be settled only in Delhi. So you have forgotten or you have deliberately avoided to raise the matter at that particular point of time, and now you want to get a transfer in the name of, that means that is what is called forum shopping, which is not allowed. Of course, he has not given any decision regarding his jurisdiction, but in one para he stated that literally the Delhi High Court has got the jurisdiction. Since they have not asked for a decision on the jurisdiction, he has not touched the point. So friends, this is briefly regarding the topic of jurisdiction as well as the transfer of the case. Now we have touched section 21 as well as section 22. This decision is basically given on section 22. That is transfer. It is a negative example. Transfer not allowed. At the same time, he held that if there is any lack of jurisdiction, it should be raised in the first point itself, not at this stage. Of course, they did not raise. They wanted only the transfer of petition, they have said. And anyway, he has touched that point also. And please remember, in USA and UK, normally whatever pleadings you file, the case will decide only on that. They will not go an inch further or further. Of course, Indian courts using their inherent powers no more than, just like in a Asia case, they will give some decisions, but normally foreign courts will not allow. That's why you must be very, very careful in drafting the pleadings. Right? Here they asked for the transfer, it is negated. Had they asked for the objection of jurisdiction, it might have been considered, but they have failed to do it. So that's why pleadings are more important. Anyway, this is a good case on jurisdiction as well as transfer. Thank you.